look at regulation of those rights. They do institution. I don't think there's any disagreement about that. The level of scrutiny for some, in this case, that the relevant fact is economic. That quibbled made that clear. In fact, I made the point that the individuals who live for economic rights, I disagreed with them. Individual I mentioned, such as Macedo. And this doesn't mean they don't exist, and it does not mean I think that that we do recognize value that is so deep in society, such as our First Amendment. But to review it as a difference, it recognizes our political process.
Well, Senator, because Professor Macedo has come up, and for the record, read a letter I received, on Friday afternoon.
This is WBUR Boston.
Esteemed book. I love his book. For giving me 15 minutes of fame. It might be hard to profess well, that's not relevant. He said, I could not agree more that natural law issue is worth pursuing and have been a bit disappointed by Judge Thomas. As a token of my appreciation, I wanted to offer a few pieces of work to you and your staff. The article, The Privacy Institution Moral Defense, the question of why something like natural law is capable, as you have said at the hearings. I send along the book, etc. Then I want to read from just one paragraph long. Sure,
this is Senator
everything
Biden.
is clear in the Macedo. He says, quote, sent to me Friday by Professor Macedo, M.A.D.O. The future act of double standard. His words, the judicial interpretations of fundamental scrutiny to challenge laws that interfere negotiated with speech, religion against discrete and insular minorities. Several explicit supports for equities and property rights test designed to establish only the merest rational basis exist for the law in question. In applying this double standard, as I shall explain at greater length below, the Moss ignores the Constitution's support for economic liberty, disparages close connections between economic and other forms of freedom, and invests legislators with unwarranted measure of trust, trampling at the core ideal of our constitutional regime, the aspiration of reasonable self-government. End of quote. I knew and everyone else knew why I asked that. Because Jefferson believes that the standard, which I understand with, and that's been around for a decade, as he points out, is one we should continue. It's one we should jettison. And that was the reason for the questions, the reason why I appreciate, whether I agree with it or not, I appreciate your answer, that you do not agree with Mr. Double, he calls it. Am I correct? I got unanimous consent that his record read. And I thank the chair for the other chair. Well, thank you very much. I'm not sitting next to Senator Thurmond. I'm never. He's the chair. But thank you very much for the interruption. And but I thought it was the record. And anyone who wants to look at the book, this is it.
Once again, Senator Mitchell.
Because you gave a lengthy answer, but I think this just takes a simple. Do you still believe that the minimum wage law isn't?
Senator, I think is that I meant it, and that is that it does have of eliminating certain individuals or precluding them from entering the job. There is data on that. I have felt.
You're talking about the impact of it to certain individuals gaining jobs. I see that the minimum wage law is a out denial, which is what stated. I think it was in 1980.
I think what I meant by it does not allow certain individuals to enter the workforce. And as I've also indicated, that was constitutional judgment. If we're talking about constitutional officer, is no, I didn't. That is not what I'm saying.
One of the most puzzling is your suggestion that we should discount most statements because those were made in your role as a policymaker. The thing is that your supporters assert that your segregated is a very important part of our consideration, and you said that your personal history demonstrates just race and poverty. I'm not sure what that's saying to us. In other words, your argument is more relevant to assessing your qualifications, speeches, and writings. And an 8-year record, while head of the Thomas, I have difficulty with that. Your tenure at EO, that is what qualified you for the court, has been so brief. Dedication of what court? By your own admission, you spoke D. Judge, I start from the assumption that officials, what they say, and advocating policy positions, did views or advocating positions to tell this committee when and why you were doing that. Policy issues as EEOC chairman, I can accept the idea that you, in the time on which you expressed yourself on a particular issue, to accept the notion that the moment you judges also required to go in on the bench, just imagine that's the way it is in the real world. If that was the case, there would be no point in looking at any of the past 16 months of your life. Record and Pizamini are usually